Okay, I've got it. Okay, now let's do this again. Okay, everyone, we're back. We're here getting some of our technical issues together. But again, welcome to the Acharyas Copyrights, the Hidden History of the BBT, a second installment of discussions with Gupta Dasa, who will educate us nicely today.
This presentation does not and is not intended to constitute legal advice, nor does it create an attorney-client relationship. It is offered for general informational purposes only. This presentation constitutes a fair use of any copyrighted materials pursuant to Title 17 U.S.C. Section 107 Fair Use Exemption and any other provision of U.S. copyright law which may apply. Copyright 2022 Tiger Pace, LLC. All rights reserved.
Okay, so Gupta ji, you are there and you can see me. I can see you, right?
I can see you perfectly, yes. Thank you.
Okay, good. So we're on. And welcome to others who are watching on Facebook and the few others that are here with us on Zoom. This recording will be available on Bird's Eye View with Garuda on YouTube, probably posted within a day's time. So, Gupta ji, I turn things over to you. We're ready for more edifying words from you, enlightening words from you. So, take it away.
Well, thank you very much for hosting again, Garuda, and broad welcome to everyone who's watching. This continues and the series, the Acharyas Copyrights, and which is based on an in-depth review and analysis of publicly available materials. The second video is entitled East and West Copyright Protocol. And what we're going to do in this video is really get an understanding of the framework that we're working with in relationship to the pre-66 works and the post-65 works, meaning the works that were, the literary works that were produced and generated by A.C. Bhaktivedanta Swami, the author, in India, and the regulatory environment at that time in India versus the post-65 environment in the United States. So as a bit of background, first, I would say that the devotees and the devotee community has really looked very closely at the issue of Arsha Prayog. Arsha Prayog basically means one cannot alter a master's text. And that's the basis for the Eastern system. And many articles have been written now for decades over which is the lens that has been used, Arsha Prayog, as to the nature of the books and how they've been improperly presented by the publisher. And that's obviously very important. We briefly touched on that last time. At the same time, we are mostly dealing with, of course, almost solely dealing with works that were produced post-65, which means that we're in a regulatory environment involving the United States, not India. And that environment is quite different. That environment is based on moral rights. Moral rights extend historically back even before Roman times, which was the the height of the Roman Empire, excuse me, which was just prior to around 2535 AD to about 375, I believe, BC. There was about a 400-year period, a little over 2,000 years ago, and moral rights, the right to the integrity of one's work, was also at that time acknowledged and revered. And as we move forward through the years, it wasn't until around 1504, a French court specifically ruled that the droits moraux, or the moral rights, would be and are acknowledged and recognized officially as a legal tenant. From there, the moral rights continued to grow throughout the world. It was the basis for understanding how to deal with the creative expression of an author. That process continued until continued and eventually wound up in a place in 1886, in which a number of countries got together and passed what's called the Berne Convention for the protection of literary and artistic works. The Berne Convention, that was 10 years prior to the author's appearance or birth in India. So in 1886, the Berne Convention began. There was only a few countries. Later in 1928, India joined the Berne Convention. And the Berne Convention was extraordinary. But before I get too much into the Berne Convention, let me step back a moment just to mention a point about moral rights in general. And if we could look at Exhibit 1, Garuda Prabhu, if you could move us to that.
Okay. I will share my screen.
Thank you.
And adjust. Okay, there we are.
Okay, so moral rights developed to the extent that eventually and we'll talk about this in detail in a moment, but that the US joined the Berne Convention on March 1st, 1989. However, there was already an existing regulatory environment in the US that was well developed since 1790, when the first Copyright Act was legislated and began. And the point of this is to see that you can go to the United States Copyright Office website. This is a 140-page document, which is extensively cited by literally hundreds of sites, which describes the author's attribution and integrity, the moral rights in the United States. There's a long tradition and history involving the moral rights in the United States, and it's just that it's handled a little bit differently. So as if we can go back now to the video portion. Okay. Okay, so the Western principle then kind of picks up on and really has two major components, which there are many components to moral rights, but we're going to look at two specifically. And the first one is the right of integrity. And that is basically the right of the author not to have his or her text be prejudicially distorted. And that's a very simple concept, is that when an author or an artist has a creative expression, no one has any right to adjust and change that without the author's permission. It's a rock bottom fundamental right that has been extant existing in cultures, both East and West, for thousands of years, probably until 1983. I'm just being a little sarcastic about that, but that's when the 83 Bhagavad Gita, the abridged edition, was published. The second is the right of attribution. And that right basically is the right for an author to be attributed, the work to be attributed to that author. Not for someone to say, oh no, I wrote that, but there's a right associated with that. Interestingly enough, we kind of have a little reverse, a converse situation, unauthorized, unending, unprofessional editing of the Acharyas' works in the last 40 years. And that's in which changes have been made to the book by others, yet it's credited to the author. Now you can, on later books, of course, they say revised and edited, but editing posthumously does not mean changing the style or the philosophy. It just means basically copy editing, which is spelling and grammar, a little bit of grammar and punctuation if necessary, and as lightly as possible in order to preserve the historical record. So with these two rights, there's been a blatant violation of these basic principles that protect an author's work by the ISKCON publisher over many, many years. I know there's all kinds of arguments why it could or should or whatever be better in a different way, but that's a entirely made up construct that has nothing to do with the underlying rights that an author has. And I would say that amongst the devotees that are and supporters and followers who are looking at and seeing this video, I would be shocked to see if anyone didn't understand that and didn't see that these two rights have been flagrantly violated over the years by the ISKCON publisher. In fact, I'd ask you to raise your hand if you don't believe that, and I would say that obviously I can't see you raising your hand, but I would say it's about the same, because no one would raise their hand, meaning that they understand that these rights have been violated to the extreme. If we can go now to Exhibit 2, Garuda, please, which is dealing with the Berne Convention. Now, the Berne Convention was an incredible document. This is the appendix to the, it was originally published on September 9th, 1886. The present one is the 71 adjustments that were made. Every few years there are certain appendices and changed revisions that occur. And if you could scroll down, Garuda, please, to Article 5. Article 5 enshrines pretty much the essence, in Section 2, the essence of the Berne Convention. If you know this, you basically will know more about the Berne Convention than most people do know, which is that the enjoyment and the exercise of these rights shall not be subject to any formality. Now that's the key, that the key to this entire approach in the Berne Convention is that an author inherently has the moral rights, and now that they're being codified, they cannot and should not be, and under the Berne Convention, are not subject to any regulatory formality. So that means that however, if a country is following the Berne Convention, it was a very liberal way of looking at exercising your ownership. Such enjoyment and such exercise shall be independent of the existence of protection in the country of origin of the work. And of course, once a country does join the Berne Convention, then this distinction is made that the work is protected regardless of the formalities involved. That's a very important concept to understand. So the Berne Convention then, we can, let's see, we can take that down, Garuda, and just, let's just take that down for a second. And I like to distinguish that now, the Berne Convention, the informality and the lack of formality to protect your rights, with the system that was began in 1790. James Madison was the key individual who pushed that through, the 1790 Act. There were 3 succeeding revisions of that act, 2 in the 1800s, and the third one was in 1909. That's why we call it the 1909 Act. It's actually just the third revision of the 1790 Act. The 1909 Act was very, very significant because one of the biggest reasons is because of the growth of and development of the budding Hollywood industry. At that point in time, for the next 20 years, through the from around that period of time through the 30s and then into the 40s, the Hollywood industry was exponentially grew. So there was need to be new ways and more efficient legal ways to deal with everything from movies to scripts to how rights would be handled. It wasn't just literary work. It wasn't just the fact that there was art, but now there was moving art and there were moving words. And that was there were many, many cases that came out. So in the 1909 Act, in that protection, that extended until December 31st, 1977. That was the period of time for the 1909 Act, which of course exactly overlays all of the Acharyas' works. The Acharya having disappearance and passing on November 14th, 1977, and the 1909 Act extending until December 31st of 97. Extraordinary. It was extraordinary because even looking earlier, during the time that the author was writing in India, the author was covered by the Berne Convention, which again meant no formalities required. And then post 65, as the author Acharya wrote for the United States copyright, under the United States copyright regulatory scheme, it was strictly construed. The Berne Convention was eventually, in 1988, an act was passed by Congress called the Berne Convention Implementation Act. That act allowed for the Berne Convention to be effective as of March 1st, 1989. To the United States regulatory environment had been very developed to protect, and it did protect very strongly its authors, artists, and the Hollywood productions for many years. In addition, there were other issues associated, regulatory issues that impacted, for example, the First Amendment. The First Amendment was another factor in the United States, as were many other factors. So rather than just accept and adopt the Berne Convention in total, instead it was considered it was not a self-executing treaty. That phrase, not a self-executing treaty, means that when the Berne Convention was adopted, it wasn't automatically accepted word for word as being provision by provision, as being the law in the land. It would have been impossible to do that. It would have been like taking a plant from one environment and transporting it into the entirely different environment, it would not have survived anyway. It would have been a litigation disaster here in the United States. So, so as that occurred, the U.S. Congress then would adopt those provisions of the Berne Convention that were appropriate. Now, fast forward to present day, many of those provisions have in fact been adopted. And there's been time for court cases to sort out the disputes in between. However, the period of time between the December 77th ending of the 1909 Act and the beginning of the March 1st Berne Convention period was a period in which the 1976 Act was effectuated. And that act was basically, for all practical purposes, it was a continuation of the 1909 Act. Most of the draconian and exacting precise requirements of the 1909 Act were continued into the 1976 Act, which ended and was replaced on March 1st, 1989. So that means that publications by the ISKCON publisher from 1966, when the first publication began here in the US, other than mimeographs, until March 1st, 1989, were essentially the lens that's looked at is the regulatory schemes under the 1909 Act, 1909 Act, and the 1976 Act, which are strict. Now, to understand some of the strictures of that, if you, Garuda, would move to Exhibit 3, there were basically 4 major areas of exacting requirements. They deal with deposit copies, registrations, assignments, or what the literature the circulars refer to as transfers, and copyright notices. Each of these, by the way, each of these circulars are available. This is Circular 7D. It's available on the US Copyright Office site. We're going to be looking at Circular 7D number 2, 12, and 3. And it's a wealth of information. They go from 7 pages to 30 pages, depending on the circular, some longer. And we're just going to briefly now look at some of the issues associated with how the mandatory requirements. In this one, it was required that 2 copies of the work would be deposited with the United States Copyright Office, which were then stored through stored then and held as deposit copies. That was required to complete a registration. The next exhibit, number 4, sets out, if you could move to exhibit 4, please, which is the copyright registration process. That registration process, there's an application, there were basic facts, entirely different again than the Berne Convention: the title of the work, the author, the name of the address of the claimant or the owner, the year of creation, whether the work is published, whether the work has been previously registered, and so on. It was required to have a great deal of information. It was a relatively simple form, but that form had to be accurate. The next exhibit, number 5, is again another stricture associated with the transfer of copyrights, which I refer to as, in this context, as assignments. We'll be looking at that issue in a future video in great depth. There's only a little over a dozen assignments that were ever filed, including the May 15th, 1990 assignment, which divested all of the intellectual property from the Bhaktivedanta Book Charitable Trust, the irrevocable charitable trust, to the Bhaktivedanta Book Trust International. So there's the transfer. This goes on for pages because it's a very exacting requirement as to how assignments are transferred. They're not done orally, they're done through a writing. The writing has to be proper. In the next section, we'll look at now Exhibit 6, which goes on to look at the notice requirements. This has to do with how and why in each of the authors post 1965 literatures, there is a copyright notice which includes a symbol and or the name, includes the first year of the publication and the name of the copyright owner. You can see the example there is copyright 2017 John Doe. There are some exceptions, but basically, if any of these components were missing, the copyright would be lost, including the placement of the copyright. It wasn't just where this appeared in the book was strictly regulated. So it had to be within a certain number of folds from the title page, or else if it was in the back, it was in the wrong place before that. If it was in the middle of the book or wherever it was, the copyright would have been lost and immediately injected into the public domain, meaning that the public would then have complete right and control over it. So now that we understand and see, if we can go to the next slide, Exhibit 7, the difference between these two systems within the context of the author's work, let's look more specifically at the Easy Journey to Other Planets, the iconic essay written by the Acharya and published in 1960. If we could scroll down to that double page, there we go. Right, perfect. Now, just go up a little bit. Okay, so this is the Berne Convention in action. What we have here is totally informal. There's a title, there's an author. If you look on the right side of the top page, you'll see in parentheses copy and then a space right, reserved by the author. And then if you look in the bottom left panel, you'll see the word copyright : author. That was it. Other than that, what was generally done was other than the author's name and that informal, however that the author decided to pretty much say that, generally it was also it was traditional and common that the publisher would be named. So who published the book? And here in the bottom left panel, we can see published by His Divine Grace, and then let's see, there's another site here as to who published it, I believe. Let's see, I don't see that right now. But the basic point here was, oh, there we go. It was printed or published by Surendra Printers in Delhi. So these are three basic points of reference in a Berne Convention printing. You'd have the name of the author. You would have some statement, however, about the copyright, but it was not formal. And generally, the printer or the publisher would be mentioned. Very simple and very, very important to understand this and remember this point, because we're now going to look at the U.S. Copyrights, which is Exhibit 8 and Exhibit 9, which is that's the cover to the 68 abridged Bhagavad Gita as it is. And if we can look at Exhibit 9, which displays the copyright notice. We'll see on this one, this is copyrighted with a small c, 1968 by A.C. Bhaktivedanta Swami. All rights reserved, no part of this book may be reproduced, and so on. All this information is very specific. There's a Library of Congress number, gives a first printing. And this is this is probably the best example that we have of how to properly copyright a book from prior to March 1st, 1989 in the United States. And the reason for that, I would say, is because of the publisher. We have a top drawer publisher here, the Macmillan Company, Collier Macmillan out of Canada, and it was printed in the United States. This information is exactly how it was properly done. Now let's move to the 72 complete edition. This is, again, the first edition abridged was around 306 pages. So this was in 981 pages, I believe. If we scroll down to the second page, again, this is a proper copyright done by the book, copyright 19 with a small c, 1972 by His Divine Grace A.C. Bhaktivedanta Swami Prabhupada. And then we have at the bottom the other information, first printing, Macmillan Company, printed in the United States. It's picture perfect. Now, just keep this in mind. We're going to look at a few more slides, and we're going to be comparing now. This is the 70. This is from 68 to 72. If Macmillan had been printing all of the books by the author at that time, I could tell you with a high degree of confidence that it would look exactly the same as this one does. So let's now look at the Exhibit 11. There are 3 books we're going to look at. This is the TLC, Teachings of Lord Chaitanya. This is a 1968 publication. We scroll down to the copyright page. Let's stop for a moment and look at this. So we have a copyright 1966. Proper copyright, proper symbol, proper year. But as we can notice, I don't see the author's name here. What I see is International Society for Krishna Consciousness, Inc., ISKCON. And that means that, and this is not a publication by Macmillan Collier. This is a publication by the ISKCON publisher. Okay, if we look now at the next exhibit, which is number 12, this is the Sri Upanishad, which was printed in the United States in 1969. I think I said 69 earlier. I meant that would have been 68. This is the copyright 1969 edition of the Isha Upanishad by, now I don't see the author's name. I don't even see ISKCON's name. What I see is ISKCON Books. ISKCON Books is, as far as I understand, is basically a moniker. It's a way of talking about the ISKCON publisher. And of course, it was printed by ISKCON Press, which are the devotees who were doing the work in-house. And if we looked at the last exhibit, 13, we can look now, taking it full circle, to the Easy Journey that was published in 1970 in the United States, compared to the Easy Journey that we've seen before, published in India in 1960. Again, I don't see the author's name as the copyright owner. I don't see ISKCON Books. I don't see ISKCON Incorporated. I see another name, ISKCON Press, as the copyright owner. Okay, so so let me attempt to summarize. We can take the exhibit down, and let me attempt to present to you some of the issues now that will take us into further videos. One of the main issues being that the author, A.C. Bhaktivedanta Swami, when he published and printed, he was conversant with and published under the Berne Convention. And when he entrusted the Bhagavad Gita, both the abridged and complete edition, 68 and the 72, he entrusted that to the hands of Macmillan, Collier Macmillan, to print those books, and was very comfortable with that. Those were picture perfect. A top drawer publisher. There was a contract we can look at later. I think most devotees have probably seen that contract. but it was clear what was allowed, only revisions by the author that was interpolated or placed into the contract specifically because the Acharya requested, and that provision that only the author could make the change, any serious revisions other than copy editing. Now, this issue associated here with having different names in the books. Now, Prabhupada looked at and saw these books. He saw them. He read them. How was he viewing them? Is it likely that he was viewing them under the incredibly complex U.S. regulatory scheme that required certain format, that required specific information, or was he more likely viewing that as he had been viewing for many, many years in India through the eyes of the Berne Convention? Not that he was using these terms, but he was used to that. You put your name, you put the publisher, and what else do? You either put a date, or at least you make some reservation of copyright. So we're going to be discussing this issue in more depth as we go forward to look at how it is that the period from 1966 to 1972 was kind of like the wild, wild west in terms of how things were actually done. I realize we're pretty much out of time. We've gone about, I believe, about 40 minutes or so.
Right.
Guruji, do you have any follow-up questions, or are we good, or shall we?
Yeah, this is I mean, I find this fascinating, but let me just ask you, I mean, in effect, the devotees were challenged by a professional copywriting of Prabhupada's earlier works that they were in charge of, that were not published by Macmillan. That's basically the thrust of what you're saying, that they really didn't know what they were doing. They sort of kind of ad hoc'd it.
Well, that's certainly the reason for it. No one actually. I mean, I think the oldest person in the movement, I think at that point, as a follower or disciple, was probably 32 or something. I knew if they were even 30.
If that old, right? Yeah.
Everyone was basically in their 20s. So it's not that there was any training. This is highly
Right.
technical legal issues. It's not even, you can't just read, the circulars weren't available in the same way. If you wrote to the Copyright Office, as some of the copyright managers or BBT managers later did, they would just be told, well, go talk to a lawyer, otherwise look at this circular, and we can't give you legal advice. As far as I know, there wasn't anybody there. So yes, you're correct. That's the first part of it, is that the devotees that were doing their best to make this work from this period of 66 to 1972 did what they did, and Prabhupada approved of the idea, of the phrase ISKCON Press as being the publisher. But now Prabhupada never spoke of the ISKCON Press as being anything other than the publisher. The second point comes to how Prabhupada's view of what was happening. Was he not viewing this? No one was running up to Prabhupada and saying, "Oh, we're under the 1909 Act, and we have to follow this circular and these rules and so on," or were they just doing what they thought they should do based on what they knew at the time?
Right.
And from Prabhupada's point of view, would it not be logical that he would say, "Okay, my name's in the book. Oh, it's great. The publisher is in the book. ISKCON Inc. published the book. ISKCON Books published the book. ISKCON Press published the book." So that would be a very natural and logical way of looking at it.
Okay, but Guptaji, but Prabhupada was there. When he's no longer physically present, how can I can understand devotees didn't know what they were doing. They were naive, innocent, unprofessional. Fine. But Prabhupada was there. It was acceptable, even if it wasn't professional or unprofessional. When Prabhupada left, I mean, we had the Macmillan professional, it's a world-class publisher. They did everything right on the copyright pages, as you pointed out. After Prabhupada leaves, what I want to know, and I think so many devotees want to know, is what gives the BBT the right to sort of take over what Prabhupada left? Did they have the right to do that?
Well, Garuda Prabhu, that's why we have probably 15 of these videos to look at. There's a lot of background information in order to even understand what the answer to those questions are.
Okay.
Now, there are answers, and they're part of the historical record. They're part of the copyright record, the registration record, affidavit records through cases. That information is, as I mentioned in the first introduction video, has all been relationally associated. So I think the answers are obvious, and they're there. But but we need to set up the stage so that can be understood in context.
Okay, excellent. And I very much look forward to that. Of course, we've got the lawyer and the scholar here, right? So from where I'm sitting, Guptaji, it's unthinkable to change the work of a deceased author. I mean, that's just, we call in Western philosophical ethics, we call that intuitionist ethics. It's just obvious. It doesn't have to go through the rational mind. It's just a gut. Like you don't do that to anybody.
Yes, and you and I will be in the next video actually discussing that issue. I'm not an expert in your field by any means. I've read and I agree with what has been discussed by devotees who understand that you can't spiritually or legally change a master's work. And so we need to have a discourse about that, because these two are the legal side of this and the scholastic side, what should be properly done, are like two wheels that need to turn together.
Okay. Well, I'm eager to turn more together with your wheel, Guptaji, and I look forward to more discussions. This is really edifying, terribly interesting to me. I hope so for those who are viewing it, and I appreciate the way you're educating us, frankly, in areas that I think most of us are just not familiar. So certainly not familiar back in the day, that's for sure. So anyway, thank you so much, Guptaji. We'll see you on next Sunday then for part 3, right?
Next Sunday, yes. And you and I will be actually having a lively interaction next Sunday.
Oh, okay. Oh, well, thanks for the warning. I appreciate that. Okay,
no
great.
Problem. Be prepared.
Thanks to all that. Yeah, okay, good. Thanks to all that have come and are viewing this video, and we'll continue in part 3. Thank you, Guptaji.
Thank you.
Okay.